Good morning and welcome to Tandem's third quarter webinar. My name is Rebecca Buckland. I am one of the senior HR generalists here at Tandem HR. Our goal at Tandem is to simplify the people processes, which enables organizational leaders to maximize return on investment in people and concentrate their efforts on driving organizational success. As HR experts, we aim our quarterly webinars to provide a value add for our client owners and their employees. To omit any static or interruptions, I have placed everyone on mute. If you have any questions throughout the presentation, please feel free to type them into the questions box on the right side of your screen. If you have personal questions, please feel free to contact me or your HR generalist offline. Today, we will be speaking about social media in the workplace. When I began to think about social media, I immediately thought of the story of Pandora and how similar the story is to the history of social media and what this training can provide. In classical Greek mythology, Pandora, who was the first woman on earth, was given many gifts: clothes, beauty, speech. Pandora was also given a beautiful container, which she was not to open under any circumstance. Driven by her curiosity, she opened it. In the box was evil, and this evil escaped and spread over the entire earth. She attempted to close the container, but the entire contents had escaped, except for one thing that lay at the bottom, which was the spirit of hope. Like Pandora and the contents of her box, we are surrounded each and every day by social media. We should not view or feel as if social media is evil, like in the story of Pandora, even if it can appear that way for us as managers in the workplace. In order to manage effectively through this age of social media, it is important to understand the history of and how to navigate through social media in the workplace. Let's take a look at what we will be speaking specifically about in today's webinar. During the social media in the workplace webinar, we will be specifically speaking about the following items: what social media is, and how social media can be defined, the surprisingly long history of social media, current day statistics or considerations of and about social media, who the governing body is as it relates to social media in the workplace, and the laws that guide that governing body's determinations on claims of illegal activity. What to consider when creating a social media policy for your company. A review of recent court cases and determinations made on submitted claims. And finally, the responsibilities of the manager. By the end of today's session, you should feel that you have the knowledge and the confidence to manage employees and your organization through an environment filled with social media. The term social media is something that is tossed around quite a bit, but do we really understand? Do we really know what it means or how to best describe it? Social media can be difficult to define in one simple sentence, in my opinion, especially if we agree that sites like MySpace, Magnolia, and Wikipedia are all social media sites. The best way to define a term is generally to break it down. Media is and has been the channels used for the means of communication. Think of this as a newspaper or radio. Social, on the other hand, is defined as a formation of cooperative and interdependent relationships or companionships with others. I would then define social media as media that is disseminated through social interactions or instruments. Specifically, does the channel, website, or forum provide you with information, or does it interact with you while providing information to you? Standard media is a one-way street. You can read a newspaper or watch a television newscaster, which does not allow you to provide your thoughts or opinions regarding the subject at hand. Social media allows for two-way interactions, which gives the user an ability to communicate as well. This interaction may be as simple as requesting comments or allowing your assessments on the topic, but can also involve much more complex interactions. Now that we have defined and have a better understanding of what social media is, we can continue progressing. With social media gaining momentum and popularity, there are now subcategories of this definition. Let's review some of the social media subcategories, what they are used for, and the websites in those categories. Social bookmarking allows the participant to interact by tagging websites and searching tagged sites by other people. The Delicious website, founded in 2003, made this social media type very popular. Social news. Social news provides interaction by allowing commentary or voting of articles. Slashdart was one of the first social news sites, which started back in 1997. Social photo or video sharing is accomplished by sharing photos and videos and commenting on those items made public. YouTube currently is the most popular of this category. Social networking is probably the most recognizable and most difficult as it relates to the workplace. This type of social media allows interaction by adding friends or associates, commenting on profiles, joining groups, and having discussions. This is accomplished through sites such as Facebook or LinkedIn, among many others. There are many websites that allow you or the participant to interact with the site. All of these sites would be defined as a social media website. What is fun and interesting about the definition of social media is that if you ask a bundle of different people what social media is, you will most likely get as big a bundle as the number of people asked. In research, here are some other definitions of social media. Answers.com says that it is the online forum of communicating to the masses. iContact defines social media as an umbrella term that defines the various activities that integrate technology, social interaction, and the construction of words and pictures. Another example, Webopedia states that it is a term used to describe a variety of web-based platforms, applications, and technologies that enable people to socially interact with one another online. Wikipedia, known as a social media site, lists social media as media for social interaction using highly accessible and scalable published techniques. One of my personal favorites while doing research is that social media is word of mouth on steroids. When you think social media, you more than likely think first of Facebook, Twitter, or LinkedIn. You probably also associate the beginnings of social media over the past few years. In actuality, the social media movement is scattered across many platforms and across many decades. Some say that the beginnings of social media actually started in the 1950s, but more commonly and accepted are that the beginnings date back to the late 1970s. Some say that the first podcasts or blogs occurred on hacked voicemail systems in the late 1950s. These hackers would gain access into unused mailboxes to communicate, at least until they were found out and kicked out. So, how was this done and what did it sound like? A user would call a corporate 800 phone number, enter an extension, listen to the recorded broadcast from the hacker, and then the user could leave their comments or information as a voicemail. The hacker would listen to these voice messages left and then respond in their next recorded message on that 800 number with extension. In 1979, the first electronic bulletin board system was open to the public. The BBSs, as they were known, were small servers powered by personal computers attached to the telephone modem. The BBS systems had discussions on message boards, community-contributed files, and online games. There was definitely an underground social media movement going on in the 1980s. There were legitimate BBSs offered, but there were much more secret, private, or pirate rooms in the background. Early in the 1990s, Prodigy and CompuServe were the very first large-scale attempts to bring interactive online experiences to users. They offered a safe, moderated environment for social networking and discussions. CompuServe was infamous for their high cost of $6 per hour, plus the long-distance charges for the telephone usage. Prodigy quickly grew in popularity and was known for its color design and lower costs. But next came AOL, who brought these social concepts to the mainstream. One way they were able to do this was obtain product placement in the movie You've Got Mail, which bridged social online culture and romance in the Hollywood mainstream. Also in the early 90s, in August of 1991, the World Wide Web was made available to the public. And from this point is when people never looked back. In addition to the prior mentioned events, around 1994, private internet service providers became available in most metro areas. This is really what provided millions of home users the opportunity to participate in what was becoming social media. 1997 brought the very first social networking website, 6 Degrees. 6 Degrees let users create profiles and connect with friends. This was predominantly known as Web 2.0. It was an interactive social web application. 6 Degrees was followed by Friendster in 2002, MySpace in 2004, and finally Facebook in 2007. Currently, Twitter is the hot trend, which is a way of moving away from static sites and into real-time streams of information or updates. Even during this past year's Olympic Games, the U.S. team members were given phones and encouraged to tweet about their Olympic experience. Location-based software is another current trend. By the way of the iPhone and other hardware, a functional web browser allows users to check in at public locations and be located by others who are in their proximity. What all the future holds is uncertain and boundless. There is one real-time social media application, Wave by Google, that is very interesting. Wave is being designed to allow users to actively co-create and collaborate on documents or projects, not just announce and comment. We will have to wait to see how this turns out. Stats are usually interesting and oftentimes fun, specifically when they are about social media. I have attempted to put together an interesting list for you today. Let's first talk about Facebook. There are now more than 955 million active Facebook users. Facebook is the most visited website on the internet, reaching 1 trillion page views in 2011. The average user spends 700 minutes per month on the site. Regarding LinkedIn, every second, 2 new users sign up. LinkedIn membership includes executives from every company listed on the Fortune 500, and 61% use LinkedIn as their primary professional networking site. Moving on to Twitter, Twitter has over 500 million users. Nearly 500,000 users are added each day. 190 million tweets are sent on the average day. And 40% of Twitter users don't tweet, but instead use it to keep up to date. YouTube is up next. YouTube has 490 million unique visitors per month, which generates 92 billion page views. More video is uploaded to YouTube in 60 days than the 3 major US networks created in 60 years. In regards to other social networks, Instagram reached 13 million users in 13 months after launch, and more than 50 million users over the past 2 years. Wikipedia hosts over 17 million articles. Mobile devices are certainly of interest. Globally, more people own a mobile phone than a toothbrush. Mobile now accounts for 10% of internet usage worldwide. There was a 103% growth in website traffic from smartphones from 2011 to 2012. And 91% of mobile internet access is used for social activities. Most importantly, though, are the statistics for social media for business. 27% of small businesses and 34% of medium businesses are using social media for business-related purposes. 80% of businesses use social media sites to monitor or extract information related to their competitors. 42% of employers say no to any use of social media in the workplace. 53% of employers have a formal policy on social media. 40% of young workers rate access to social media at work above receiving a higher salary. over 50% of workers aged 50 or above use social media every day at work. Finally, just some general social media statistics. Women are more active on social media than men, 55% versus 45%. And 57% of people talk to people more online than they do in real life. 83% of people believe platforms like Twitter and Facebook help them make new friends. 25% of people believe social networks have boosted their confidence. I will conclude with this. Currently, every minute of every day, 100,000 tweets are sent, 684,000 pieces of content are shared on Facebook, 2 million search queries are made on Google, 48 hours of video are uploaded to YouTube, 47,000 applications are downloaded from the App Store, 3,600 photos are shared on Instagram, and 571 websites are created. Again, this is every minute of every day. Social media has advanced so rapidly that the laws have failed to keep pace, leaving employers in a difficult position. The concerns we have are regarding employee privacy, negligent hiring, and company property. And there is very little in the way of established legal standards for organizations to rely on. The National Labor Relations Act is a federal law that regulates employer and union relations. The NLRA affords employees, even those who are not unionized, the right to engage in concerted activity, including the right to discuss the terms and conditions of their employment with coworkers, even if it is to criticize their employers. It is very important to know that under the NLRA, an employer may not implement a policy that would reasonably tend to chill employees in the exercise of their rights. The National Labor Relations Board, or NLRB, which was established in 1934, is an independent agency that is responsible for investigating and resolving unfair labor practices. The NLRB is led by a president-appointed and Senate-approved 5-person board and a general counsel. The NLRB's regional directors, who oversee the NLRB's regional offices, and the Division of Advice, a branch of the General Counsel's office, decide whether or not an unfair labor practice charge is of merit, and therefore whether to issue a complaint. If a complaint is issued, absent settlement, a trial will occur before an NLRB administrative law judge. Section 7 of the NLRA provides employees the right to self-organize, to bargain collectively through representation of their own choosing, and to engage in other concerted activities for the purpose of other mutual aid or protection. I just mentioned one of the most important terms when dealing with the legalities of action related to social media in the workplace: concerted activity. Concerted activity is activity engaged in or on the authority of other employees, and not solely by and on behalf of the employee himself. Concerted activity also includes circumstances where individual employees seek to initiate, induce, or to prepare for group action, and where individual employees bring truly group complaints to management's attention. A good indication from the Labor Board is that they have held that individual employee gripes are not concerted activity. Another term that we need to speak about is protected concerted activity. An employee's concerted activity will be protected under Section 7 of the Act when the employee's statements implicate the employee's working conditions, regardless of how those statements are communicated. Another example of protected concerted activity occurs when the employee protests supervisory actions. However, these protections can be lost where the employee's outbursts are too critical. The use of curse words alone is not likely to reach this level. Protection could also be lost when the employee's communication is disloyal, has the tendency to damage, made with reckless disregard of the truth, or are just maliciously untrue. It is important to remember that the NLRB's guidance on social media applies to all employers, whether or not their employees are unionized. So you may be sitting there thinking, do I, as the employer, have any control over what is done or said on social media? Yes, you certainly do. I would recommend that you take a balanced approach. You should balance the interests of the organization and of the employees. This balanced approach is certainly not a new or innovative concept, but one that really exists in most employment law. There are many times legitimate interests on both sides of the equation, employee and employer. For example, the organization has the right and ownership of employee communication on company-owned computers. But employer rights with respect to monitoring and controlling employees' personal communications are not limitless. Even more specifically, the courts have focused on the balance of restricted conduct and the legitimate business interests. Courts have found that employers do not have a legitimate business interest in the content of personal communications, but do have an interest in the fact that an employee is spending working hours occupied in non-business related subject matter. Some activity that you could potentially discipline for are employee gripes about management that are not an attempt to initiate or induce coworkers to engage in group action. Comments made to those who are not coworkers and the employee was not linked with any coworkers. Posts that are merely communicating with friends about the happenings at work, if there are no complaints or expressed concerns in the posting. Defamation of a manager by making maliciously false remarks. An important reminder that false remarks cannot be prohibited, but maliciously false remarks can. Please understand that this is not a black and white issue, and the provided examples are not a yes you can or no you cannot list. Whenever making adverse employment decisions regarding an employee and social media, I would advise speaking to your HR generalist prior to action being taken. This is because if an employer disciplines or discharges an employee for engaging in protected activities, an unfair labor practice claim may be made under the National Labor Relations Act. This may result in mandatory reinstatement of the employee plus any retro pay for lost wages. The NLRB's General Counsel has increasingly been using his power to issue and prosecute unfair labor practice claims against organizations that have taken adverse actions against employees for social media activity that the employer considered detrimental to the business. In addition, the General Counsel has issued complaints against organizations for disseminating social media policies that were overbroad. The General Counsel believes that these overbroad policies tend to prohibit employees from engaging in protected activity. The General Counsel has focused efforts in social media policies that are considered overbroad and therefore in violation of the NLRA. An example would be a reviewed policy that stated the employees were not permitted to have, quote, inappropriate discussion about the company, management, or coworkers. The General Counsel stated that this was prohibited due to the policy being overbroad. This is because it could reasonably be read to prohibit or restrict employees from exercising their rights to discuss terms and conditions of employment. A really great example that could happen to each of us was the General Counsel found a policy overbroad that prohibited employees from posting pictures in any media that depicts the company in any way, which included the employer's logo and photographs of the employer's store, brand, or product. The General Counsel's view, a requirement of this nature could restrict employees from engaging in protected activity, such as posting pictures of lawful picketing that showed the company name or logo. The good news is that the General Counsel has provided suggestions on how employers can more narrowly create a policy to stand a better chance of being legal. Social media policies are elevating in importance every day as social media usage becomes more prevalent. It is good to mention that even when social media sites are blocked via the company's server, employees' use of smartphones and after-hour use of social media can certainly affect employers. Ensuring that you have a clear social media policy in the company's employee handbook is the organization's first line of defense with the NLRB. It is important to have a guide for employees to follow, because if your employees are left to guess what kind of conduct is permissible, you and your organization may face serious legal issues. It is imperative that you create, distribute, and enforce a comprehensive social media policy that allows your organization to take advantage of opportunities while protecting itself against legal risk. At the same time, you should use great caution when writing social media policies because of the prior discussed scrutiny by the NLRB. There is not a one-size-fits-all for social media policies. Every organization has different needs and uses for social media, and they all have different risks being managed too. Remember that the best social media policy is the one that is tailored to fit the organization. When creating a social media policy, you should ask yourself and document the following, as this will be the basis of your organization's social media policy. The first and most important aspect to consider is what the policy is going to accomplish. This can be assisted by knowing what the organization's goals and objectives are, and how do they translate to social media. For example, are you attempting to educate employees on how to use social media? Does the company need to limit company liability for the employee's actions? In other words, manage risk. Do you need to control information that is provided to the public and address reputational concerns? Is the company just attempting to comply with federal regulations? Are your social media policy intentions consistent with other policies, guidelines, and the overall culture of the organization? This is one of those tensions companies face when they are trying to determine how restrictive to be in their policy. It is prudent to make a social media policy that is consistent with the other company policies or procedures, applicable government or industry regulations, and your corporate culture. If you are able to determine the details of these questions posed, your social media policy will be clear and consistent, which makes your organization well on their way to success. Specifically, the policy should begin with an overarching value statement, potentially reminding employees that the use of social media at the workplace is a privilege, and that privilege comes with responsibility. A contained statement on what constitutes social media is always nice. It could then continue with the company's expectations and limits for the employee's usage of social media tools. For example, the company expects that the use of social media during work hours must not interfere with the employee's optimal performance of job duties. The policy will be served by specifically listing what topics are not permitted. The policy should include what the employee would expect to incur if they violate this policy. For instance, the employee may be subject to discipline or termination if the policy is violated. When developing a social media policy, it is most important to not create an overbroad policy or one that would reasonably chill the exercise of protected concerted activity rights under the NLRA. These type of policies could be deemed illegal in their entirety. In addition to the social media policy, I would recommend that organizations create and distribute an employment reference policy that expressly applies to social media. This policy should include who can provide employment references, the information that can be provided, and that the company is not liable for any unauthorized references. Once you have established the details of the company's social media policy, the organization will need to ensure that the policy itself is not going to violate the National Labor Relations Act. Even if a policy does not explicitly restrict protected activities, it could be deemed unlawful if the employee would reasonably construe the language to prohibit Section 7 of the NLRA. Some points which are commonly included that should not be prohibited in the company's policy are gossip, rude conduct or discussions, and pictures. These have all been considered to be too broad as listed. Disparaging comments. This is also too broad, and it does not inform employees that it does not apply to Section 7. On the other hand, your policy can certainly include the following: a restriction of employees speaking on behalf of the company. A special note: you cannot restrict the employee from speaking to the media, just not on behalf of the company. That the employee cannot disclose confidential information, as long as it is clear that this does not prohibit the employee from discussing their wages, benefits, or discipline. A statement prohibiting harassing statements and/or pictures, and prohibiting employees from violating the privacy rights of clients and copyright or trademark protections. Although it will not excuse any improper policy statements, you will want to consider including a disclaimer regarding the employee's Section 7 rights and how this policy is not intended to violate those rights. We will most certainly need to monitor very closely the ongoing legal developments and conform to any changes as they occur. Social media policies are generally created to protect employers, but on occasion, a policy can take away the protected rights of employees. This is what the NLRB is concerned with. During late 2010, the National Labor Relations Board determined that they were going to focus efforts on employers that use overly broad social media policies to suppress employees' rights to engage in protected concerted activities under the National Labor Relations Act. In the first case, which ended in settlement, involved a medical transportation company. The claim was that the company illegally terminated an employee for criticizing her manager on Facebook. In the company's employee handbook, the policy stated that employees were prohibited from making disparaging comments when discussing the company, employee supervisors, co-workers, and competitors. The actions leading up to this claim were a customer complained about an employee. The employer investigated the incident while the employee went home after being denied representation. The employee, on her own time and on her own computer, posted disparaging comments about the supervisor on Facebook. The employee also compared the supervisor to a psychiatric patient. The employee's co-workers on Facebook made sympathetic and supportive posts. The employee was then terminated. The NLRB then brought a complaint against the employer, saying that they violated the law because the employee was engaged in protected concerted activity. It is important to remember when an employer has a policy that tends to chill employees in their rights to discuss wages or working conditions, the company can be liable for violating Section 7. In this example, unfair working conditions were being discussed, hence the claim that the employer acted unlawfully. One of the best ways to provide guidance and ensure understanding is to simply review claims or cases that have already occurred. The General Counsel has released a report that summarizes cases in which it was concluded that the employer's discharge of employees for social media conduct violated the NLRA. In the first case, a manager accused employees of not pulling their weight, and some of those employees went on Facebook to complain about it. They were then terminated after the manager found out. The employees' actions were considered to be taking a first step toward protecting themselves against such accusations. This was deemed to be protected concerted activity, and the termination of these employees for such activity violated the NLRA. In another case, in preparing for a meeting with management, an employee asked coworkers via Facebook post for their reactions to another employee's complaint about work quality and staffing levels. 4 coworkers responded with posts. The employee, who was the subject of the Facebook discussion, complained to management about what she perceived as harassment and cyberbullying by the others. The employer, a non-for-profit organization, then fired all 5 employees who posted the Facebook messages. The General Counsel viewed the employee's request for assistance from coworkers as concerted activity and concluded that the terminations were illegal. Finally, in a case involving a Chicago area luxury car dealership, a salesperson criticized his employer's handling of a sales event to promote a new car model by serving hot dogs and snacks, which he considered cheap food, unbefitting the image of the dealership, and sending the wrong message to potential customers. He also posted mocking photos of the event that included his coworkers. The general counsel felt that the employee was simply vocalizing the concerns of his fellow employees about an event that could have an impact on the employee's compensation, which consisted entirely of commissions. Therefore, the employee's expression of those sentiments was protected, and his termination was illegal. As a reminder of some things to keep in mind when determining if a situation is protected under Section 7, the use of social media must involve commentary regarding the terms and conditions of employment. Profanity and insulting language in posts will generally not justify discipline if used in the course of protected concerted activity, and social media activity must be concerted or in some way involve other employees. The General Counsel's report also provides summary of cases in which it was concluded that the employer's discharge of employees for social media conduct was not a violation of the NLRA. The first involved a bartender in a restaurant in Lombard, Illinois. He had a conversation with his stepsister on Facebook. When she asked him about his night at work, he responded with a complaint that he had not had a raise in 5 years and that he was doing a waitress's work but did not receive a share of her tips. He also called the restaurant's customers rednecks and said he hoped they choked on glass as they drove home drunk. He was fired after the employer discovered the comments. The bartender complained to the NLRB, but the General Counsel ruled in the company's favor. Although the bartender's posting addressed his terms and conditions of employment, he did not discuss his Facebook postings with any of his fellow employees. There had been no employee meetings or any attempt to initiate group action. In this instance, the employee was merely responding to a question from his stepsister about how his evening at work went. The second involved a customer service worker in an Oklahoma Walmart. The employee complained on Facebook about a specific manager, using some crude language and profanity. In this case, the NLRB concluded that the Facebook remarks were an expression of an individual gripe. There was no indication that suggested the employee sought to initiate or induce coworkers to engage in group action. Finally, the board's General Counsel addressed the case of an employee of a group home for homeless people with mental problems. The employee, working on an overnight shift, posted to her Facebook wall, "Spooky is overnight. 3rd floor, alone in a mental institution." Another poster responded, "Who will you tell when you hear voices?" The employee wrote, "Me, myself, and I. One of us has to be right. Either way, we'll just pop meds until they go away." The conversation continued, ending with the comment of another friend, "I think you'd look cute in a straitjacket." Again, the NLRB saw no evidence of protected concerted activity, and in fact, her Facebook post did not even mention any terms or conditions of employment. The employee was merely communicating with friends about what was happening on her shift. At this point, it is pretty clear that employers can discipline employees for their personal comments made in the social media world, when those comments are simply an individual's gripe about an individual and management, rather than an attempt to initiate or induce coworkers to engage in group action. The comments are made to those who are not coworkers of the employee, and the employee is not connected with any coworkers on the specified site, and the posts are merely communicating with friends about the happenings at work. Of course, Claims can get a little tricky, and this is why it is always best to consult with your HR generalist prior to taking any adverse action on an employee. For example, an employee on Facebook was complaining about customers and also about the company's policy regarding employee tips. The recommendation noted by the council was that the tipping complaints were probably concerted activity, but the termination came about due to the comments about the customers, which were inappropriate, so the termination was upheld. As you can see, rulings from the NLRB can shape the way law is interpreted in the future. It is certain that there is not yet a clear and sure path. I would like to take this opportunity to inform you of new Illinois legislation passed on March 22, 2012, which is an amendment to the Illinois Right to Privacy in the Workplace Act. This bill was signed by Governor Quinn on August 1, 2012, and takes effect on January 1st of 2013. The Act now prohibits employers from requesting or requiring any current employee or applicants to provide their passwords or related account information to any social networking site for the purpose of accessing the site or providing access to their social networking site in any manner. The law does not prohibit an organization from establishing and maintaining workplace policies which restrict the use of the company's technology, such as computers, internet, or social networking sites while at work. The law does not prohibit you from monitoring employee usage of company technology. Finally, the bill does allow you to search the public domain for information regarding employees or applicants. Managers need to be especially careful about their own personal and professional use of social media. Information posted by the manager may become accessible to the public, and comments made can certainly be used against the manager and the organization. All managers should be made aware of good social media practices and expectations. This is to reduce risk and prevent liability for themselves and the company. An example of when a manager's or even a coworker's comments can have legal implications is by way of LinkedIn's recommendation option. If a manager provides a positive or glowing recommendation of an employee on LinkedIn, and that employee is later terminated, the terminated employee could make a claim against the employer that the termination was due to something other than performance, since the employer already provided documented statements on the positive performance or behavior of the ex-employee. This can certainly work in reverse as well. If a manager recommends an employee and fails to disclose negative information, this may lead to claims by third parties for negligent referring. Another example of when a manager's statements or post could cause legal ramifications for the organization would be if they were to make discriminatory statements, and those statements were seen by others. These statements could certainly be used in the defense of any employee's claim. The thought behind this is if a manager makes comments on their feelings or beliefs in their personal life, how related is that feeling or belief in their professional environment? I always like to remind managers that they are the face, the emblem of the company that they work for. Managers should at all times be professional and responsible for the decisions that they make in their personal time. They should also be aware of how their decisions may impact the company that they represent. This rings true as it relates to social media. What a manager does on social media should always be a good representation of the company. Of course, we need to ensure that the manager's concerted activities are protected at the same time. Again, as a reminder, a manager should never take adverse action with an employee regarding social media usage until they have consulted with further management at the very least, and hopefully their human resources department. We reviewed a lot of information this morning. When summarizing this webinar, I would state, social media is media that is disseminated through social interactions or instruments. Social media began in the 1950s and is still progressing stronger than ever before. I'd like to say today is tomorrow's history. Every minute of every day, hundreds, thousands, millions of social media activity is occurring. The NLRA is governed by the NLRB to ensure that protected, concerted activity is maintained. Policy is key, must be compliant, and will continue to evolve. Managers need to be aware and be provided with support. Social media is not evil, like Pandora experienced in her story. Although it does surround us and can certainly feel daunting, especially with how much it has evolved in a very short period of time, and how it will continue to grow and change. I hope that you feel that you have been given Pandora's box of hope today by way of Tandem's third quarter webinar. With respect for your time, we will be answering all questions asked today with a personal email to you within the next 48 hours. If you have any further questions, please type them into the question box on the right of your screen, or certainly contact me directly. Thank you for your time that you have spent with us today. I hope that each of you have a wonderful day and rest of your week.